SJC 11920, Eventmonitor, Inc., v. Anthony Leness.
Good morning, Mr. Dunbar. Thank you for your flexibility, as well as to Ms. Kaplan for the second shall be first. So you may proceed.
Good morning, Your Honors. May it please the Court, my name is Ronald Dunbar, and I represent the appellants, Eventmonitor, Inc., and Sheldon Chang. Your Honors, this case presents the perfect example of why the Commonwealth should adopt the after-acquired evidence doctrine. In this case, we have an employer in Eventmonitor who, without cause, terminated Mr. Leness and, under the contract, was paying him his severance. And about 2 months into the severance payments, discovered for the very first time that Mr. Leness, on the other hand, was not doing the right thing, that he was actually engaging in wrongful conduct by subscribing in October of 2007 to a public website called Carbonite, which is a backup website, and taking and uploading to that website Eventmonitor's confidential and proprietary information.
Does the record indicate, I know October is when he's signed up for Carbonite, but does the record indicate when he actually did the uploading?
It does, Your Honor. It's Mr. Lacasse's testimony, the forensic expert, says between October 17th of 2007 and December, I believe, 6th of 2007, the information, the proprietary information, the financial information, the contracts of Eventmonitor.
It was all before the termination without cause notice was given? Is that what you're saying?
Absolutely, and I believe that's undisputed. It's all before the notice of termination was given that the Carbonite site was used and all of the information was uploaded to that site.
And it's not disputed, is it, or is it, that he did nothing with the information? Or are you just saying you don't know?
We just don't know. That's the
There's no evidence that
there's no evidence. That's the peculiar part of the case. It was done. Thank goodness Eventmonitor learned it, and then once he was caught, he gave it back. But the wrongful conduct from Eventmonitor's perspective and under the contract is the actual taking of this asset, this proprietary information, putting it up onto a website, and then not returning it until he was caught and told that he had to.
Well, he returned it. It means he didn't retain any copies?
He did not retain any copies. As far as we can tell, he said he returned it all. And
So the question I have is, was this during the period of time where negotiations were going on? Did he copy this material during the period of time when negotiations were going on? It was clear that things were, not perfectly harmonious with the president of the company.
So, Justice Lang, with respect to negotiations, do you mean between Eventmonitor and Mr. Leness?
Right.
Okay.
About the
SpinCo proposal?
SpinCo, yeah.
Sure. Yeah, so during that time period, Mr. Leness was given the task of putting together some kind of proposal where Eventmonitor would spin off into another company. And during that time period, he was gathering information, putting this proposal together. Right around when he presented the proposal in October of 2007 to Mr. Chang, that's when he was uploading the information. It had no connection to what he was doing for SpinCo.
No, but it may have, things were not going well, I gather, with the president of the company.
I think
didn't like his proposals and who thought that there was, who was actually plainly preparing to terminate him anyway at some point, although not for cause.
Right, I'm not sure if there was he was prepared to terminate him at some point. Relationship had become strained. The information was uploaded. Mr. Leness's proffered reason, which was totally rejected by the trial judge, was that he didn't think Eventmonitor had an adequate backup system, which the trial court judge said, well, I don't believe that, because they do. And even the trial court judge was a little perplexed as to why he was doing it. Nobody really tied it to the SpinCo proposal, but nevertheless, he did it.
But look,
Go ahead.
no. Well, at the time that he did it, which was before the notice of termination without cause, and I'm looking at this, at the cause definition, and assuming, which the judge didn't, but just assuming that defalcation includes this asset, that is the proprietary information, it requires willful fraud or defalcation. And so if you think of defalcation as misappropriation or misuse, if he's still employed by the company, he hasn't gotten notice without cause, what's the misuse? What's the misuse in uploading it to the Carbonite backup system?
Well, the misuse, Your Honor, and I think that defalcation, I wasn't reading into that misuse. I'm reading it more as of a taking, like the trial court judge said.
Appropriation.
Taking of money, or the equivalent is how the trial judge interpreted it. I say taking of other property, because that's the way it was talked about here. So the wrongfulness is taking it and moving it to a site that's not within Eventmonitor, given all the confidentiality provisions in the agreement and the proprietary information that this information consisted of. And the wrongfulness continued on when he didn't return it. So once he got notice, he held on to this. He was asked, what information do you have on which websites? He responded and excluded that purposefully from his response. Didn't give the website, didn't give the password.
Right, but I guess I'm really trying to figure out if you're thinking about after acquired evidence, and at least as I understand the doctrine, the evidence needs to be before the time when the termination happened. And so if I use the date of the termination without cause, I'm just trying to figure out what was the.
Sure. So from Eventmonitor's perspective, the wrongfulness, the defalcation, was the physical taking, was the taking of the information, uploading it onto a public website without justification, without explanation, without telling anybody. And the acts that happened after his termination notice, he was still employed. There was a 30-day time period where he was still officially with the company.
Right.
Everything happened within that time period. So not giving it back, scrubbing the computer. I believe the dates are, the C cleaner was used to scrub the computer on January 2nd. January 5th was the last official date that he was in the employ of the company. So everything happened within the 30-day termination period. Everything but the scrubbing happened before the termination notice.
So when you talk about after acquired evidence, that you're talking about evidence regarding misconduct that occurred during his employment?
Yes,
Okay, that's clear.
that's clear.
So how far do you go with this? I mean, let's assume you had discovered this a year later and you'd already paid the severance. Under your argument, would you then be able to demand the return of the money and bring suit to for the return?
I believe you would, Your Honor. The case that sets this out the best is the McDill case, the Supreme Court of New Hampshire case decided in 2000. And they set out a three-part test. And the three-part test in McGill is the plaintiff was guilty of some misconduct of which the employer was unaware. The misconduct would have justified discharge, and if the employer had known of the misconduct, the employer would have discharged the plaintiff. In McDill, it's actually cited in footnote 10 of the Massachusetts case Przinski. That's a case where it was a termination for cause under a contract, and the Supreme Court of New Hampshire said, we're going to limit this to the situation that does not involve terminations that violate public policy or terminations of discrimination or retaliation, which I would suggest the court could do here, and that would take care of the amicus concerns that in certain situations this could be misused. The Supreme Court of New Hampshire, in their case, they said, we're going to limit it to this contract-type case and set out a very easy three-part test, and we fit that here.
But I guess my concern is an employee who is terminated. Well, first of all, even without this doctrine, if you had damages, you could have sued him for breach of contract to recover damages. Even without this, I mean, you have no damages because he didn't use it. But if there were truly a misappropriation and there were damages, you could have still sued him even without the after acquired doctrine, correct?
Correct.
So this submerges really with regard to issues of severance where there's no damages. Is there not some view that, I mean, you did fire him without cause, so that was what you did, and now you want to redefine it later. I guess my concern is an employee essentially agrees to go gently into the good night because it's without cause, and then weeks, months, maybe even years later, the employer says, no, actually, that we're going to redefine what actually happened to be with cause, and we're going to treat it as if it's if cause, and the employee is left saying, well, you know, I would have done something differently had I known that that was what the employer was going to do.
I think, Your Honor, how the test addresses that is that it's not a blameless employee. It's not making up evidence after the fact. It's an employee who has to engage in misconduct.
Well, you say misconduct, but your severance arguably could have said that any time you maintain any copy of any corporate document, that that's a basis for termination for cause, and we're going to, and I mean, it doesn't, I mean, you define it, termination with cause to be defalcation, which you're defining rather broadly to include the copying of any document and the retaining of any document, but need not.
Right, and I think we're specifically just sticking with the language that's in this employment contract, the defalcation of other assets of the company. That's what Eventmonitor is focusing on, and that very specific for-cause provision is what we're saying was met here such that Eventmonitor didn't have to pay severance.
Right, well, I understand that, but I mean, but you didn't, the contract need not have said defalcation. The contract could have said any material breach of the agreement.
And it may not fit into the after-acquired evidence doctrine if you couldn't prove that the employee engaged in misconduct. I think the key is it's not an employer trying to catch an employee after the fact with made-up reasons for terminating them or taking away severance that was granted. It's sort of a fairness that if the employer is completely ignorant to the fact that the employee was engaging in misconduct, and that misconduct is later discovered, and the misconduct rises to the level, as we believe it does under the provision of this contract, that would allow us to terminate for cause, then that after-acquired evidence can be used to justify the termination. It's such a very specific test with a relatively high hurdle. I mean, you have to show employee misconduct that rises to the level of a contract provision that's already been negotiated. And the trial court found that both sides had lawyers. It was freely negotiated. These were the terms that they came to. Mr. Leness is a super bright guy. This was the agreement that they agreed to. And the after-acquired evidence, you have to find some wrongdoing on behalf of the employee. It's not just a blameless employee.
But the judge here, I take it, found that this, whatever occurred here, wasn't really a material breach.
Correct.
So if it doesn't rise to the level of a material breach, then this after-acquired evidence process wouldn't make a difference, right?
Well, it does. It's two separate arguments. So the after-acquired evidence goes to the willful, it's not willful,
But
I'm
you
sorry.
just said it has to
Goes-
rise to the level of
Right.
something that would be...
Right, so the after-acquired evidence is used two ways in this case. One is to say that there was defalcation of company assets. So we learned that after the fact. The other way it's used is that those acts were a material breach of the contract, and in and of itself, separate and apart from the contract provision, a material breach by one party relieves the other party from its obligations. So we're relying on two separate reasons to not pay the severance. One is we could have terminated you for cause. The second is what you did was a material breach of the contract. Therefore, we are relieved
Not
of
one
our
and the same.
obligations.
So this after-acquired evidence, which was not sufficient to constitute a material breach of the contract, would still be sufficient to terminate for cause? Is that what you're saying?
It would be because the trial court judge didn't get it right on defalcation. I think what the judge didn't get correct was defalcation of company property. He was saying the company assets, that what happened wasn't defalcation.
But I
think
thought he said even if it were, it wasn't material. Didn't he say that?
No, I think what he said was he was talking about keeping it and not giving it back was not material. I think if he would have found that the taking of it was defalcation, that would have been a material breach. And I think that's where he got the defalcation part wrong, and the rest of the opinion flowed from that because the defalcation part was incorrectly decided.
Now you've confused me, because I thought before that there had to be a willful defalcation or fraud to justify a termination for cause, and now you're telling Justice Cordy and us, no, there's a wholly separate ground that any material breach of the agreement would also be a termination for cause. Is that your position?
No, my position is the willfulness is not, first of all, it doesn't go to defalcation, it's just defalcation. The willfulness goes to fraud.
Well, that's what you say. That isn't
That's what I say.
necessarily the case.
And I think that's the way the contract reads, but it's a second ground, separate and apart from a material breach. The material breach of the contract is separate and apart from the for-cause provision. It's just black letter case law that if one party materially breaches the contract, the other party is relieved of its obligation. And I'm saying that the evidence showed that what Mr. Leness did in using the carbonite site was a material breach. That's separate and apart from the specific contract provision that we're relying on to say retroactively he could be terminated for cause and the severance doesn't have to be paid.
All right, thank you.
Thank you.
Shauna Kaplan, on behalf of Anthony Leness, I have with me James O'Connell Jr., who was the lead trial counsel. There are 4 issues before the court today. The company wants you to resolve 2 of them, which concern Mr. Leness's breach of contract claim. Mr. Leness is also asking you to resolve 2 issues, one concerning his indemnification claim and one concerning his Wage Act claim. I'm going to start by addressing the company's breach of contract issues first. Here, the lower court found, as we have been discussing, that the company breached the agreement by the party's employment agreement by failing to pay Mr. Leness the severance that he was entitled to under the agreement. The company raises the after acquired evidence doctrine as a defense to this claim, and there are a few reasons why we think the doctrine shouldn't apply here. We also believe that even if the doctrine were to apply, that it wouldn't affect the outcome of this case.
Let's say, I mean, I take it you're not arguing that if the company in these circumstances, after your client left, discovered that he had been embezzling money through his expense account, that you're not saying that that wouldn't be grounds for converting a termination without cause to a termination for cause, are you?
Well, I think here it wouldn't be grounds to stop paying severance payments. I don't think the doctrine applies here. This is a contract case, and contract principles should apply here. And the parties could have negotiated a definition of cause that would have said something like, if the company discovers after Mr. Leness is terminated, that Mr. Leness engaged in conduct that would have constituted cause at the time of termination, then the company can stop paying him severance.
Well, doesn't after acquired evidence, it's never written into the contract.
Well, but in the typical situation, the after acquired evidence doctrine arises where there's been a wrongful termination. There's no issue here about Mr. Leness's termination. The sole issue is whether he's entitled to benefits under this contract. And
Well, it goes to what kind of termination he had, right?
It goes. Yeah, but I think that what kind of termination he had in this context was a not-for-cause termination. The contract itself defines, and other courts have found, that in a situation like this, where we're talking about the right to benefits under a contract, as opposed to whether there existed cause or lawful grounds for termination, that it's not appropriate to apply the doctrine. If you think about the doctrine has to do with conduct that an employee committed during the course of their employment that could have formed the basis for a cause termination, but that was unknown to the employer. And when you're looking at wrongful termination, I think that you're asking whether that employee has a claim to that job, and you're looking at damages that are in the nature of future pay. Here we're looking at a contract that defines employees' right to benefits that are effectively compensation for services rendered.
So are you saying that the only time this doctrine applies is in wrongful termination cases, when it's not the employee is suing for having been wrongfully terminated and the defense is, I could have fired you for cause?
I think in
I have?
I think in the vast majority of the cases where this is applied, it's a wrongful termination context. I think that because the parties could have negotiated, in this case, a cause provision that included this kind of doctrine, they could have negotiated this doctrine and included terms that are analogous here, but they chose not to. They didn't. In fact, they did negotiate times when severance would stop. They said that if Mr. Leness was employed after severance began, that they would stop paying severance. So
you're suggesting that in Justice Corey's example, if he had undeniably defalcated money by stealing funds right out of the till, and they didn't discover it till afterwards, they'd have to pay him the whole year?
well, then they would have other claims. I mean, that's not what happened here. The court, they
I'm
brought.
just trying to see where you limit this doctrine.
Yeah, I don't think that the doctrine would affect because I don't think that the doctrine would affect his entitlement to severance under this contract in those circumstances. I think that the company would have other claims, and here they brought other claims. I mean, they argued here that he converted the property. They brought an affirmative claim that he converted the property, and the judgment entered in favor of Mr. Leness on that claim, and they don't appeal that.
So if he had brought a claim against the company for wrongful termination for cause, and was able to show that the cause on which his employment had been terminated, in fact, wasn't true, the doctrine would apply in those circumstances if the company could show that, look, yeah, we relied on a particular cause that has since been disproven, but we had a cause that was not known to us at the time that we could have raised, and therefore your termination has been properly effectuated.
That's when the doctrine applies. That would be my position, that's when the doctrine applies, that it would apply to limit damages in that situation, because the issue is whether the employee is entitled to future damages. I mean, the issue is at what point in time, we need to make an assessment in those types of cases, at what point in time is the employee no longer got a claim to that employment that was wrongfully taken from them?
If you're wrong about the interpretation of defalcation, and if it does include the wrongful retention of or obtaining of proprietary information, how does that interplay or interact with Section 6B of the contract, which seems to allow the employee to retain copies of proprietary information until such time as he's terminated?
Right. I think that even if defalcation, which I mean, I don't think that defalcation can include intellectual property, but even if it could, the judge's unchallenged findings here established that Mr. Leness didn't engage in the conduct of defalcation, if you will. He didn't steal or embezzle anything. He didn't deprive EM of its use of the property. He didn't convert the property to his own use. He didn't intend to misuse the property, and he didn't misuse the property. So I think the judge's findings here established that even if the property could be intellectual property, he didn't do the conduct that constitutes defalcation. And because there is no defalcation here, and this is where the judge came out, even if we consider this doctrine, even if we apply this doctrine here, it doesn't affect the outcome of the case, because there was no evidence that Mr. Leness engaged in any conduct that constituted cause, even if you considered all of the evidence that the company put forth. And some of that evidence concerned things that happened after the termination decision was already made and was communicated to Mr. Leness. And I think that that too is a stretch of the doctrine that isn't appropriate here. I mean, the doctrine looks at what the employer could have known but didn't. And here the company testified at trial that had they known not just that he copied the documents and retained the documents, but that he scrubbed his laptop of the evidence of that they would have terminated him. And some of this evidence has to do with things that happened after the termination decision was already made.
You mean after the no-cause determination?
After the no-cause
But
determination
within the
was
30 days afterwards.
within the period that he was still at the company, but after the determination had been made, right? And that's a stretch of what the doctrine says, and it's not necessary because here we have other claims available. I mean, the company had, the claims that it brought as potential remedies available to them, and they were unsuccessful here, but we don't need to create a new remedy for employers in that circumstance. Going back to a point that we were just discussing about defalcation and the meaning of that, it's also our position that defalcation can't apply to this intellectual property, that it has to apply to funds. The overwhelming authority in this, on what the meaning of this term is, indicates that this is a word that means embezzlement.
Yeah, but it seems to me your brother is arguing that you can define a banana to mean an apple in the terms of a contract, in that they've defined defalcation here to mean something that is not ordinary, but that includes intellectual property.
He is relying on the term in the contract that says funds or other assets.
Right.
And it's our view that assets, even in that context, has to have a pecuniary meaning. I mean, defalcation, words of a contract have to be read in context. They can't be read in isolation. And although you could define an apple as a banana, here, assets we have to understand what the meaning.
Yes, but assets, I mean, it clearly doesn't mean funds because it says or other assets. So it's something different than funds.
Right, so it would be our view that it can include, other items that can be liquidated.
A computer.
Stocks, bonds, not a computer. A computer is property. I mean,
Not an asset?
That's what asset usually means.
Well, an asset can mean a tangible asset or an intangible asset. It can mean an asset that has a pecuniary.
So your view is that if Mr. Leness had sold that, sold the information to a competitor in return for money, that would not be defalcation?
If he had sold the asset to a competitor for money, I think that, well, first of all, I mean, that didn't happen.
I know, but I'm trying to see, you say it would not include intellectual property, but
I don't think that's what the word means. And the parties could have chosen the words, any words that they wanted to use. I mean, if they had wanted to say that cause could be, they could have defined cause as stealing anything.
But asset has a meaning that is different from what you are limiting it to, I suggest.
I think that if
In
you
a
read
usual meaning that
right,
has it.
I think if you read asset in isolation, that perhaps it would have a broader meaning. But given that defalcation, I think that because defalcation is a word that we don't commonly use, that it might be easier to lose sight of the importance of reading asset in context. But it's like saying if an employee can drink fruit punch or other nourishment. Well, nourishment can mean pizza, but in that context, if you say nourishment is pizza, it doesn't make sense. It's nonsensical because you can't drink pizza, but you can't drink pizza, so you got to read it in sort of the context of what it says. And here, I think that.
So are you also saying, though, that somehow within the context, when you even if other assets included intellectual property, the fact that there was nothing that was thieving about. That there's something that there is a quality to the word defalcation that includes somehow taking a taking of this for illicit purposes.
Benefiting
from something like that. Is that what you're arguing?
That is what I'm arguing. So that even if defalcation does involve intellectual property or property in general, that regardless, the judge's unchallenged findings here and even the conversion judgment established that Mr. Leness didn't engage in any kind of wrongful conduct that would rise to the level of defalcation. Yeah,
so the definition that we commonly use for stealing something is to permanently deprive somebody of something. Well, you're not, if all he did was copy it and keep the copy.
And then return it.
And he returned the copy.
Yeah, or even if he didn't return it, but never used it, never sold it. Has the company been deprived of anything?
Right, and that would be our
for
position.
For a defalcation, for theft purposes.
Right, so that no defalcation existed in this case. The company has also raised the point that the breach, that Mr. Leness committed a material breach. It's our view that the judge got it right, that merely retaining a copy of the document was not material here, and that it didn't excuse the company's performance. We also raised 2 issues on appeal. The first is indemnification. The parties' agreement provides that the company will pay the costs and expenses incurred in connection with any action in which the employee was made a party by reason of the fact that he was an employee of the company in which capacity he was serving at EM's request.
But isn't it likely that the company meant in those circumstances a third party bringing suit against him and the company for, for negligence in providing whatever they provide?
Well, the parties didn't limit it that way.
So you're suggesting that, let's say that different facts, but that Eventmonitor had won on every single one of its claims, you'd still get indemnification?
I think that we would still get indemnification, because if it was a third party, I mean, there are cases that established in the Commonwealth that it is not against public policy for someone to indemnify a wrongdoer of, for the costs and expenses associated with the litigation.
Well,
So your
it's one-
view is that if he had indeed embezzled funds and they sued him to get the return of those funds, that they'd have to pay his legal fees?
Well, I guess, we don't have to answer that question in this instance, because he didn't. I mean, what we have
No,
here,
but your interpretation,
I think that the language would support that. I do, because the language is very broad. It's not limited to third-party actions, and it doesn't have an element of fault associated with it. But given that here what we have is action that was brought against Mr. Leness that he won, it squarely falls within the scope of the party's indemnification language.
all right, thank you.
Thank you.